Hi, I'm Jesse David Eisenberg with the JDE Law Firm. I'm a business litigation attorney, which means that my business is to protect your business. Today I want to talk about what happens if your LLC does not have an operating agreement. But first, I want to say that if you have any questions about what you're going to hear today, you want to talk about your business, or you think you have a potential case, all you have to do is go to meetjde.nyc. That's meetjde.nyc, and you could book a 10-minute phone or 30-minute in-person consultation with me. Now, what happens if your LLC doesn't have an operating agreement? Everything I'm about to tell you is based in New York, but most of it can apply depending on the laws of your state, but pretty well across the board. But in New York, it is required that every LLC has an operating agreement. Now, not every LLC does, so there are protections in place in the law for those LLCs that don't. So I've come up with 7 things that can happen to your LLC if you don't have an operating agreement. The first is any member of the LLC can enter into a contract that binds the LLC without consent of the rest of the members. Meaning, if you have 3 members, one can decide to enter into a lease on behalf of the LLC, and the rest of the members have to stick with it. Number 2, a majority of members, meaning percentages, and you have to figure out exactly what that is. But basically, if you have 3 members who all put in 1,000, they're all pretty much equal members to the LLC. So if 2 of those members decide that they want to add a 4th member, well, they're the majority, they can do that. Okay, so you can add a majority, you can add a member. The majority can dissolve the LLC without the permission of every member. The majority can sell the assets of the LLC without consulting every member. The majority can also, I'm sorry, not the majority. Any member cannot withdraw from the LLC without dissolving the whole LLC. You're stuck there. The majority can create a operating agreement. So if 2 of the 3 members, in my example, you all put in 1,000, 2 of the 3 can make an operating agreement, and it can even be oppressive to the 3rd member. You can make up rules or take away voting rights depending on how it looks. There are some protections in place, but you can create an oppressive operating agreement. But you need a majority no matter what if you don't have an operating agreement to create one. And you cannot expel a member of the LLC without an operating agreement. So, same example, 3 members all chipped in an equal amount. One of them decides they want to start stealing from the company. They call and badmouth the other members. They're just an awful person. Can't get rid of them. Okay, but what can you do in most of these cases to protect the company? Create that operating agreement. Get a majority of the members together, create an operating agreement to reflect how you would actually like the company run. Okay, I hope this was informative. You figured out what happens when an LLC does not have an operating agreement. And just to clarify, LLC is called a limited liability company. But if you're watching this video, you probably have an LLC. Now, just to remind you that I am Jesse David Eisenberg with the JDE Law Firm. I'm a business litigation attorney, which means that my business is to protect your business. And if you liked what you heard today, you would like to discuss a possible case, or you'd like to discuss your business, all you have to do is go to meetjde.nyc. And if you like the content you heard today, you want to hear more of it, please like and subscribe to hear more of that. Thank you for watching and listening.